John has visited us quite a few times over the years. So welcome back, John, coming from
Thank
Florida,
you.
right?
Indeed, I am in St. Augustine, Florida, and part of me would really like to do this in person because I love the human touch, but part of me thinks, it's sunny and warm here, and you might have sun in Illinois, but I'm thinking warmth, not so much. So I'm happy to be doing this by Zoom. Glad you invited me back. Thank you, Denise, for the invitation as well. My name is John Stanis, as you can see from the screen. I'm with the law firm of Masuda, Fanayev and Mitchell. I practice in commercial contracts, employment law, and litigation relating to those two areas. I like a variety of different things. As Katie said, I think this is maybe fifth time I've done this for you all. Don't quite remember. I'm going to try to leave some time at the end for questions, but honestly, if people want to pop up with questions, that's okay too. I'm all right with being interrupted. I won't be able to really look at the chat, so if you send a chat question, I won't be seeing that.
John, I got you covered. I'll take care of that for you if that does come up.
Awesome, appreciate that. And the reason I like interruptions is I find it boring to listen to myself talk on end. So I'm okay with interruptions. Okay, now let's get at it. One of the things, as I mentioned to Denise, I think last week, that, I'm afraid this might be kind of a boring program, in part because there weren't any massive, huge developments in the past year. There were various amendments to different statutes. There weren't any big case law that came out that really needs to discuss. So what we're going to be talking about is kind of nuts and bolts things. Some of it's going to go into effect in January. Some of it went into effect within this past year. One is actually something that went into effect last year, but I find that some people don't seem to know about it. So I thought it would be a useful reminder to people that this is out there and you need to be aware of it. So this page sort of lists the topics that we'll be going through. And why don't we have at it? Okay. First one is that there was an amendment to the Illinois Human Rights Act. And one of the things that had not been covered before and was unclear in the case law is whether the prohibition against discrimination based on disability also applied to people, in other words, discrimination based on their being associated with somebody with a disability. Maybe somebody that they're representing in a sense, or speaking on behalf of, or simply friends with. So the legislature has enacted a change to the Human Rights Act, saying that associational or disability associational discrimination is also prohibited. This really just brings the state into what the ADA already prohibits. Of course, one difference is that the ADA covers employers for 15 or more employees. State of Illinois, it's one, which I've never fully understood. If you're the only person in the company, how you're discriminating against yourself has always been a bit of a mystery to me, but I suppose it's theoretically possible. We've had attorneys who are so stubborn they end up having fights with themselves and it becomes physical. So I guess I could see somebody discriminating against themselves. Another amendment, this one's a little bit bigger, is also to the Human Rights Act, and it is what is called the Crown Act. It stands for Create a Respectful and Open Workplace for Natural Hair Act. Illinois is, I think, maybe like the 6th or 7th state to adopt a version of a Crown Act. And the basic premise is that it prohibits discrimination against people based on their hairstyle, if that hairstyle is either historically associated with a particular race or perceived to be associated with a particular race. So, the statute provides that but essentially what they did was they took the definition of race and said that race includes traits associated with race, including but not limited to hair texture, hairstyles, and you can think of a variety of different hairstyles that might be associated with particular races. So you look at that and say, okay, what are we supposed to do with that information? I think the main takeaway would be first go to take a look at your employee handbooks, look at your grooming policies, looking at what you're permitting or not permitting. Obviously, that varies a great deal depending on the type of business you have, and also the position can make a difference. But take a look at your grooming policies and make sure that there's not some sort of a hidden bias in there. And make sure that any restrictions are truly job related and necessary, as opposed to cosmetic, if you will.
John, and that's one of the questions about hair color. Does hair color come into this as well?
It's not entirely clear, because what the statute dealt with was textures and styling. And so they're talking about things like cornrows or an afro or other ways of doing it. I did not see any discussion. There's certainly nothing in the statute about coloring your hair, but I suppose that could be, because you can have people who color hair because they're trying to conform to somebody else's perception of what they should be like. So for example, in Japan, it was quite a trend for a long time for younger women to dye their hair a light brown as opposed to the black hair that they would naturally have. That could be considered associated not necessarily with a particular race, which is what this amendment deals with, but it could be gender oriented. And that's usually where you have problems with grooming policies, is because of gender bias. As for the coloring of the hair, I don't know. I have a daughter who's just yesterday got her hair dyed emerald green. She looks like something out of the Wizard of Oz. She's not here
That's
right now.
great.
I asked her and my wife to leave the house so I could speak freely about them during the seminar. But I don't know that a dyed hair color would necessarily be associated with a particular race. I think if you're talking about a natural hair color, that might well be, and that might become an issue. One of the things that they did with the amendment when they went to define race, as I put on the screen there, it says that race includes traits associated with race, including but not limited to hairstyles. So you could look and say, what other traits might be associated with race? That phrase is actually broader than the name of the Crown Act itself. So is that going to be interpreted to say what other traits are associated with race? Yeah, possibly. But you would think that that was already something that would have been prohibited in terms of discrimination or making decisions based on it. So it's a bit of a uncertainty there, but as with most laws, when they're not clear, we kind of count on litigation to clear things up for us.
John, one question I have is, I do have a gentleman at work that has very, very long hair, and it's actually very beautiful. He wears it up, but the other day he asked me if he could wear it down. Now, he's Hispanic, and I did hear about the Crown Act. I mean, am I okay to tell him, yeah, you can wear your hair down if you want?
Yeah, I think you would be. I mean, again, you'd look at what work he does and whether there's a safety issue, any kind of a sanitation issue. For example, I know you don't work in a restaurant, but if you were in food service, that would be
Yeah,
something to look at. But if he wants to wear his hair down and he wants to have it long, if you were to say no, then you perhaps have a gender discrimination problem, because you're not going to say the same thing to a woman typically.
right.
And you don't want to get into the business of enforcing and measuring and say, well, employees can only have hair 2 feet long or shorter.
Yeah.
Most people don't need that, and really, what's the point for that type of a rule? That's why grooming policies are really fraught with danger in so many respects, whether it be hair or clothing. It's difficult because what you're really going for is a professional appearance and something that's presentable to people.
Mhm.
But what, where that line falls is very personal and subjective. So it really can be kind of a minefield, if you will.
Okay, thank you.
But don't tell him that you think his hair is pretty. That probably wouldn't be the way to go.
Well, all the
Unless
women
he's already on the line.
No, actually, he took his hair down the other day at work, and all the women were like, "Oh, that's beautiful."
Okay. Well, so far as he's not offended, right?
Oh gosh, no.
Okay. All right. This next amendment I want to talk about, this is one that was actually adopted last year, but I keep bumping into people who don't seem to be aware of it. And the legislature amended the Human Rights Act to restrict the use of criminal convictions in employment decisions. It's not just in hiring, it's in any situation, whether it be promotion, training, everything else. And the basic rule is you can't use a criminal conviction in making an employment decision in Illinois unless there's a substantial relationship between the conviction and the employment issue, whether it be hiring or promotion or whatever, or there's an unreasonable risk of safety to that person, other people, property. In both situations, you're going to want to look at the circumstances. How long has it been? What was the conviction for? How many times were they convicted? Are there signs of rehabilitation? How old were they? So if you've got somebody who was convicted of, say dealing drugs when they were 17 and now they're 45, the relevance of that may be almost nothing. On the other hand, if you have somebody who's been convicted of embezzling twice and they applied for a job in your accounting department, that's substantially related, and you'd be able to say, no, thank you. I've actually had that happen. Handling embezzlement cases is one of the things I most enjoy working on. And I saw one guy went off and he got a job in somebody else's accounting department. So we made sure to send a subpoena to them for information, and they kind of got the point. So the other thing that that they made and implemented in the amendments to the Human Rights Act is that there's now an entire process you have to go through. Everybody knows you need to get consent before you can do the background search. You have to comply with the Fair Credit Reporting Act requirements. But now the Human Rights Act also requires you to give a written notice to the employer, the applicant, of your preliminary decision and an explanation of the employer's reasoning. So you have to notify them in advance and say, here's what we're thinking of doing. We're thinking of not offering you the job because you were convicted of embezzlement. And then the employer, the applicant, has an opportunity to respond. There's supposed to be an interactive dialogue, kind of like an ADA accommodation situation, where they get a chance to explain what happened in their past, why they don't think it's an issue. And then you have to give them another notice saying, if you decide to go through with the decision, that, here's our final decision. You have any internal appeal rights you might have, and you have to tell them that they have the right to file a charge with the IDHR, the Department of Human Rights. So
John?
it's yes.
Oh, sorry, I didn't mean to
No, it's
interrupt.
okay.
I
I
was
was just
going
going
to
to say
ask,
it's more involved. Yeah.
with a reasonable accommodation, and you said it's like the interactive process, what's a reasonable amount of time then, right? When you think about people that take leaves, we offer 14 days that they have to respond and apply that paperwork. Or is it kind of the same concept with this?
Well, you mean in terms of how long they have to respond, or?
Yes, like a reasonable amount of time before you go to that next step, like notifying them, hey, we're actually not
Yeah,
going to offer you that job.
I would wait 5 days at least, give them the opportunity before you go to the final decision. In most situations that I've dealt with, the applicant, and typically this comes up with applicants, it's not terribly common. You run a background check on your existing employee, but some companies do. There may be security related positions or fields where you have to do that regularly, for example, in transportation. But in most cases, the employee knows what you're talking about, and they'll turn around and tell you what happened, or they'll just kind of hang their head and say, all right, fine, I'm leaving. Sometimes the issue is when they don't disclose it or they lie about it on their application. Then you look and say, well, can we decide not to offer it because they lied about it? But usually that's not going to be the most solid of basis for not offering employment to somebody. And I suspect that many companies, when they deal with this, they say, let's find another reason. We're not going to base it solely on this. There will be other reasons as well. And that's what also makes it a bit of a difficult claim for individuals to pursue, because usually an employment decision is based on one single fact or criteria. So, ODRISA, or the One Day Rest in 7 Act. The statute as it currently stands, basically the purpose of this Illinois law is to allow employees to get some rest once in a while, if their children will allow it, and so the concept was that everybody should get at least a day off a week. Okay, that's fine. But really what they mean by everybody is not everybody. They don't mean part-time people. They don't mean people who are exempt under the FLSA. So you're talking about non-exempt full-time people. By part-time under the Act, it's people who are working less than 20 hours a week. So the way the Act currently reads is an employee must be given at least 24 hours of rest in every calendar week. Well, if you have an employee who gets off day 1, they could then get off day 14 at the other end of the next week, and in essence be required to work 12 straight days. The legislature kind of realized, well, that could be a problem. We're not sure how many people are doing that, but the concept of getting people 1 day rest in 7 doesn't mean 1 day of rest every 12 days. So they amended it to essentially replace every calendar week with a consecutive 7-day period. In other words, rolling 7 days. If you look at any point in 7 days, there has to have been at least a day off in there. Now, it could be every 7th day. You can give somebody Sunday off, for example. But the idea there is that you've got to allow them to have the rest. It has to be, of course, without any duties being imposed. The second change, a question? No? Okay. Thought I heard something. The second change they made is to add in a second meal break for employees who are going to be working at least 12 hours. As you all probably know, under Illinois law, if somebody's scheduled to work 7.5 hours, they are required to get a 20-minute meal break in there. And now the law says that if somebody's scheduled to work 12 hours, they get a second 20-minute meal break. For reasons I don't understand, they also specified in the amendment, well, I guess I understand it, but it seems like a solution to which there wasn't a problem, but they specified that an employer cannot count time spent in the bathroom as a meal break or a meal period. Now, you know, there's problems with people who take their lunch at their desk and don't get out. I have not heard of employers saying to an employee, I'm counting that bathroom time as your lunch. I haven't heard of employees who are actually eating their lunch in the bathroom, certainly not at the office. And so I'm not sure what problem they were solving, but somebody must have had an issue with it and decided we ought to amend the law to provide for this. This doesn't mean that you can't address employees who take an unreasonable number of bathroom breaks for whatever reason and spend all day in the bathroom. You can still address that. What this is saying is separate from that. Essentially, they're saying meal breaks are not bathroom breaks. And so don't count the two as if they are the same.
And John, we got a question about this saying, is this
Sure.
a federal or Illinois? And I believe you said Illinois, correct?
This is Illinois, yeah. In fact, everything I'll be talking about today will be Illinois laws. So it's Illinois focus. So yeah, this was an Illinois law. It's been around for quite a while, and they haven't amended it, to my knowledge, since they adopted it at the very get-go. But they amended it not only to add in the meal breaks, but they also have some new notice requirements. So you're going to have to post new notices, get your new posters. I went to the IDOL website the other day, and I still didn't see their recommended notice. You also need to give notice to employees who, if they're working remotely, you can't just post it up in the lunchroom if nobody's coming to the lunchroom. The requirement is that for remote or traveling employees, you notify them either by some sort of an internal website that everyone has access to, or by email. And that's probably a decent practice given how many people are working remotely anyhow. Pretty much all new policies ought to be shared that way. The fines and penalties were greatly increased. It used to be before, I think it was $25 per violation up to $100. Now it's $500 or $1,000 per offense, depending on the size of the employer. And I think it's if you have more than 25 employees, you're up to $1,000 per offense. So if you don't give the person that 1 day rest in 7, that's going to be $1,000. If you don't give them that second break, if you got somebody who's on a 12-hour shift and they don't get that second break, that's $1,000 every day. of the 1,000 or of the 500, depending on the employer size, half of it goes to the employee and half of it goes to the state. And I think there was a specific fund that it will be put into.
John, we have a couple questions coming through.
Sure.
Do we need to post a notice if we don't have employees who work with this sort of schedule?
Well, you want to have a notice on the 1-day rest and 7 Act anyhow, so you might as well go ahead and post it, because you're going to need to include that. And even if you don't, because it's not just about the 12-hour shift and the second break, it also relates to how the statute works and the way the statute's been amended in terms of the 1-day rest and 7. So I would go ahead and post it.
And the amendment goes into place January 1st, 2023 is what you're saying with these updates.
Yes, correct. One other point that I did want to make is when we talk about state law requiring a 20-minute meal break, which strikes a lot of people as fairly short. Under the FLSA, the Federal Department of Labor's take is that employers that permit coffee breaks, bathroom breaks that are relatively short, those are still considered to be compensable time for FLSA purposes. And the the U.S. Department of Labor's take is that any break that's less than 30 minutes is still going to be compensable. So if you want to stop the clock, it's going to have to be at least 30 minutes to be non-compensable. So you can comply with Illinois law by giving a 20-minute break, but if you're not paying them, which Illinois law doesn't require that it be paid, you're going to have to extend that another 10 minutes to comply with the FLSA.
John, the last question that we have is there a set notice form for this act, and where can I find it? Where can we find a lot of these updates?
The Department of Labor is supposed to have come out with a form notice. When I looked last week, I didn't see it on their website, but they have a form notice. And most companies, they use a poster company, and they buy a new poster every year, a new set of posters. It should be on there if you're buying Illinois specific ones.
And I know SHRM has a vendor, guys. If you haven't looked on the National SHRM website, that you can buy from that vendor, and they've been incredible with having those updates in there.
Yeah, that's actually where our firm gets our posters as well. So, okay. Next one, the Family Bereavement Leave Act. This law used to be known as the Child Bereavement Leave Act, and the purpose is to allow employees to take time off if a child passed away. They've expanded that, and so that it's now expands to include not just children, but parents, stepchildren, siblings, grandparents. So you've got your steps, you've got your in-laws, you've got basically your family. It includes domestic partners. So who's a domestic partner? It includes a definition there. It includes anybody who's in a committed relationship with the adult employee. And so the purpose of the act is to give people time off. They get up to 10 days of unpaid leave. This act is sort of, but not quite, part and parcel with the Family Medical Leave Act. And by that, what I mean is it applies to employers and employees who are covered under the FMLA. So you've got to have your 50 employees within a 75-mile radius. The employee has to have a year of service in which they've worked 1,250 hours. So the requirements to be covered under the Family Bereavement Leave Act are the same as under the FMLA. The other provision is, of course, the FMLA will give you up to 12 weeks off to take care of somebody who has an illness or to take care of your own illness. And what this does is it covers, if they pass away. So in that sense, the purpose is different, but they're a little bit related. The other thing that is a little bit odd is that if an employee has exhausted his or her FMLA time, then they don't get Family Bereavement Leave Act time. On the other hand, if they take the bereavement leave first, then they can still take the full 12 weeks of the FMLA time. Obviously, life does what it wants to do. You don't necessarily get to decide in what order you're going to take the different leaves because you don't decide when you're going to get sick or a family member is going to get sick or when they're going to pass away. but it's got that kind of an odd quirk that depending on which comes first, you might or might not be entitled to additional leave under this act. Excuse me. As with before, this covers bereavement for somebody passing away, but one of the other new changes here that they've expanded is there are other covered events, and that can include having a miscarriage, lost pregnancy, a failed adoption, failed surrogacy, stillbirth, all sorts of pregnancy and childbearing related events can occur, and those are also covered by the Family Bereavement Leave Act. Now, one of the difficulties is the employer is allowed to ask for documentation that a covered event has occurred, but many employees aren't going to want to provide you the details of their personal life. So there is a form that can be used by the medical professionals that just simply says, this employee has suffered a covered event in the Family Bereavement Leave Act, period. And that's all the employer is entitled to, is that type of a documentation that has occurred. Of course, the employee can provide more. And traditionally, if somebody passed away, you bring maybe a card from the funeral or the death notice or something like that. But because they've expanded the act to cover more intimate things, they also changed the documentation requirements to address that reality. The Freedom to Work Act. This is an act, let me scroll down there. No, I guess I had the bottom there, sorry. This has already gone into effect within this year, at the start of the year. And essentially it's a new, they've amended it to provide that non-competes and non-solicitation agreements have minimum compensation thresholds. I also have trouble with that word. So if you want to have a non-compete agreement with an employee in Illinois, or for whom Illinois law might be the governing law, they have to earn at least $75,000 a year. It's either going to be their projected or actual earnings. If you want to have a non-solicitation agreement, which basically says you won't come back and try and hire other employees away, or you won't try and take our customers away, the employee has to be earning at least $45,000 a year. Those amounts are set to bump up in, as it says there, in 2027, 2032, 2037, going up by $5,000 a year for the non-competes and $2,500 a year for the non-solicitation. One of the key factors that they also changed in the act is to say that if you of course, to have a non-compete agreement and to have it legally be enforceable, like any contract, you have to have what we would call consideration. There has to be some benefit provided to the employee. And so, if you're providing a non-compete agreement at the start of employment, it's fairly simple to say you're getting new employment here. But if the employee is an employee at will, you could have them sign the non-compete agreement, fire them the next day, and then what, enforce the non-compete? That hardly seems fair. And so the Illinois courts, as a matter of case law, have decided that if you're talking about at-will employment and it doesn't last for at least 2 years, that by itself will not be adequate consideration for a non-compete agreement. However, the federal courts, in looking at the same issue, have said, we don't think the Illinois Supreme Court would actually do what you appellate courts have been doing. We're not going to enforce that rule. So you had this dichotomy where if you were in state court, you have one rule. If you're in federal court in the same state of Illinois, you may have a different rule and a different outcome. To address that, they actually put the state court rule into the statute to provide that at-will employment of less than 2 years is not by itself adequate consideration. There can be other consideration. There could be money paid. There is a provision that said you can have other professional benefits, and that may be training that you provide to people. You would want to be very specific as to what training or opportunities you're providing, because that's a fairly nebulous thing to say on that basis. You want to have somebody not compete with you for 2-3 years sometimes.
And John, when you're talking about the salary, are you saying that that's also including bonuses as well, or that's just the base
Straight up
salary?
salary
Okay.
base. Yeah, because bonuses typically are discretionary or they're contingent on achieving certain financial goals. So going into a particular year, you don't know if you're going to get that or not. So that's just base salary. It's not including benefits. It's a good question. Another change they made to address the situation I've seen a lot is if you want to present a non-compete agreement to a new employee, somebody you've made an offer to, you have to give them that agreement at least 14 days in advance. Give them an opportunity to review it. You also have to notify them that they have the right to consult with an attorney. That's kind of like getting a release and a release of age discrimination claims under the Older Workers Benefit Protection Act. You have to notify them in writing. You know, you have the right to consult an attorney. You have X period of time, in that case, 21 days. But here they're saying you cannot present a non-compete agreement to an employee as part of your onboarding procedures because it's simply unfair. So you make somebody an offer, they quit their other job, they have no employment, they show up to your door and you say, oh yeah, now we'd like to tie you down even after you're gone. And we're not going to pay anything for it either. There's a fundamental lack of fairness of that. And so now we've got this requirement saying that they have to have it at least 14 days in advance. Now, the same as the 21-day review under the Older Workers Benefit Protection Act, the employee doesn't have to take all 14 days. They can decide, no, I'm good with it, I'll sign it, and that's fine. But that's their decision. They need to be given the opportunity. The other change that they made in the statute is to provide that if there's litigation regarding the enforcement of a non-compete agreement, if the employee is considered the prevailing party, whether as a plaintiff or a counter plaintiff or whatever, or even just as a defendant, the employee shall recover attorney's fees. So if you're going to sue an employee and you want to enforce a non-compete, if you lose, you may be on the hook for their legal fees. That's a big shift because anyone who's been involved in litigation knows lots of times it's the legal fees that become the driver of what happens or doesn't happen in a lawsuit.
And John, what do you do with your current workforce then? With some of these changes to the Freedom to Work Act, would you recommend?
I'm sorry, go ahead.
I was going to say, what would you recommend?
Oh, sorry. Well, first, if you have non-compete agreements out there and they predated the amendment to the statute, they should still be valid in a technical sense. But you've got to believe that if you're going to enforce a non-compete with somebody who earns $30,000 a year and you had them sign it 7 years ago, a judge will not be looking in your favor on that point. So I would take a look and just say, and this should be done fairly regularly anyhow, who do we really need to have these agreements with? Who are the key people? It should not be an across the board approach where everybody is prevented from working for any other company that does what we do. Some of the courts have said in somewhat a snarky way, all right, you're preventing them from taking any position with this other company, even janitor? They can't go be the janitor? Don't you think that's a little overly broad? And that's one of the key concepts in analysis of non-compete agreements is there has to be a legitimate business purpose that the company is trying, or legitimate business interest that they're trying to protect. And it has to be written in a way that is not so broad that it goes beyond what they're really trying to protect and what they have a legitimate interest in. The courts tend to not like non-compete agreements because by their definition, they're restraints of trade. You're preventing people from working either in a particular field or in a particular area. And anything that smacks of overreaching, courts they'll find a way to not enforce that. One of the things you see in that area is you get a lot of variety of decisions. Partly that's because they're very fact specific, but also it's because it's almost a gut check by courts. They look and say, all right, who's being true and who's screwing who? And I'm going to get to the result based on my sense of, and that's from a country song if y'all don't know that, but I didn't just make that up. But it's a sense of justice, of who's really doing wrong here, and then they'll get to the result they want. There's enough case law out there to manipulate it. So I would look at your existing agreements, your existing workforce, and say, who do we need these with? And if you have agreements out there for employees who aren't meeting these minimum thresholds, I'd reconsider it. Even if you have the possibility of enforcing them, I'd think twice and even consider terminating them. Not the agreements, not the employees. Need to be clear there. Another important point to keep in mind is this does not affect a company's ability to have confidentiality agreements or trade secret protection agreements or assignment of invention agreements. Those are separate and they are not affected by this. You can have a confidentiality agreement or trade secret agreement with an employee at any level of compensation, and you don't need to have the 14-day review. So sometimes those are all wrapped into the same agreement. There are other times where you separate them out, because even if one fails, you still want to be able to enforce the other one. So that's another approach to consider. Okay, the Workers' Right Amendment to the Illinois Constitution. I think most of you probably went and voted back in November. And if you're like the rest of us, you read an amendment that's usually at the back of the ballot and scratch your head and say, I wonder what in the world they're trying to accomplish. We've had several on the ballot here in Florida where I just read them in advance and I had to research them. I'm licensed to practice law here, and I had to research to figure out what they're trying to accomplish. I didn't understand it. So the Illinois voters recently approved an amendment to the Illinois Constitution. It says two basic things. One is that employees have the fundamental right to organize and bargain collectively through representatives of their own choosing, in terms of hours, wages, working conditions, and to protect their economic welfare and safety at work. Okay, but employees already had similar protections under the National Labor Relations Act, which is a federal statute. So what's the purpose or effect of this amendment to the Illinois Constitution? It's not entirely clear. This talks about choosing to bargain collectively and to organize through representatives of their own choosing. Does that mean somebody not a union? It's Jimmy and me. Jimmy's going to represent me when we go to have a harassment investigation. Maybe. One of the problems with this amendment is it appears to be in conflict with the National Labor Relations Act, in the sense that the NLRA already provides that employees have the right to act, to engage in concerted activity for their mutual aid and protection, for the negotiation of wages and benefits and work hours and working conditions. And so, the Supreme Court, the U.S. Supreme Court, has said that although the NLRA does not expressly preempt state statutes, if you're talking about protecting activity that is arguably or actually protected under the NLRA, then the federal law is preemptive. In other words, you can't have a state statute or a state constitution that tries to cover the same field that the NLRA already covers. So before this amendment went on to the ballot, there was a lawsuit against it trying to invalidate it and have it removed. And the federal court said that it was a little too early because you don't know if it was going to pass or not. They say the question isn't ripe for a decision. Now that it was passed, I think it went into effect on, what's today, the 8th? 3 days ago. It would have been on the 5th. I don't know if somebody's filed the lawsuit yet. I wasn't checking the court dockets, but I would be surprised if one or more business groups have not already filed a lawsuit seeking to hold that this amendment is preempted by the NLRA. And of course, federal law is supreme over state laws. So there will undoubtedly be a legal challenge to this portion of the Workers' Rights Amendment. The second part of the amendment is different. And it basically says that no not only can the legislature, but no home rule city in Illinois can pass an ordinance that prohibits an employer and a union from requiring all employees to be part of the union or to pay wages. In effect, there are other states, fairly good number of them now, that have what are called right to work acts. And it basically, those acts say the opposite. They say to employers and unions, you cannot have a collective bargaining agreement that requires all employees to be part of your union or to pay an agency fee to your union. People have the right to work without being a part of the union or paying the union, and any CBA that says otherwise is void under the law. Illinois is passing what is in effect an anti-right to work act. And so this amendment says that any city and the state cannot adopt a right to work law. It's basically prohibited now in Illinois. Of course, the legislature probably wasn't going to do that anyway, but many of the cities have the right to home rule and can adopt their own ordinances. So what they're essentially saying is nowhere in Illinois can you adopt a right to work act or ordinance. I don't know that there were any. Again, I'm not familiar with any municipality in Illinois that has a right to work ordinance. So it seems almost like they've adopted a solution to a problem that wasn't there. But politicians sometimes do funny things, right? So both parts of this amendment kind of make me scratch my head, not that I'm against the substance of what they're talking about, but it seems like this was not really a problem requiring a solution. So I think I already discussed those issues. Okay, here's an amendment that went into place at the start of this year. Again, I'm not sure how prevalent or common this is. There is the Artificial Intelligence Video Interview Act, and it imposes obligations on employers to ensure that if they're using video interviews in the hiring process, they have to follow certain procedures. In this case, what they're saying is that if an employer relies solely on AI or artificial intelligence analysis of a video to make the decision as to whether they will select a person for an in-person interview, then they have to collect data and report it to the Illinois Department of Commerce. They have to collect data on the race and ethnicity of the applicants who are selected, who are not selected, and for who's hired. And by selected, I mean selected for an in-person interview. So you've got to be tracking that data. I don't know of even a single client that is using pure artificial intelligence analysis of video interviews to determine who they're going to call in for an interview. Do any of you do that? I'm thinking not. So again, I'm not sure why they adopted this requirement. Maybe they're looking forward to the future where people are hired without any human involvement. You submit your application online, and then you go ahead and you do an interview. You talk to yourself, and if AI likes you, you get an interview with a real person. Have we gone that far? I don't know.
John, I don't think the government's very proactive.
No, generally not. But this one, again, it just sort of makes me look and say, I didn't know that was a problem. I actually didn't know of anyone who's doing this. But now they've got a solution and another government reporting requirement. So, that way, it doesn't say that you can't use AI to do this analysis. It just says, if you're doing it, we want you to collect the data. And presumably that's so that at some point somebody can say, is this having a disparate impact on certain people, whether it be by race, ethnicity? Why they just require the reporting of race and ethnicity, I don't know, because it could be gender, it could be all of the various categories that are protected under, the Human Rights Act. But I can see where there could be a concern if we ever get to that point, but why they adopted this now, I'm not sure, honestly. Equal Pay Act amendment. This one was adopted in March of this past year and went into effect immediately. And what it requires is that for companies that have 100 or more employees, in other words, you're filing your EO1, that you must apply for an equal pay registration certificate. And to do that, you have to go onto the Department of Labor website, register your business. When you register, they'll then tell you when you need to file your application. It's going to be sometime between March of this year and March 2 years, from now, 2024. And then after you file your application, you have to do it every couple of years. The application process requires you to submit your EO1 report. You also have to have a list, a more Illinois-based list, which will be providing the gender, the race, ethnicity, job categories, but also reporting by county, total wages paid to employees in the grid that you would have for the EO1 report, and anything else that they decide they'd like to see. Because along with the filing the employee list in the EO1, there has to be an equal pay compliance statement that has to be signed by an officer of the company. And what that statement has to say is, obviously, what we're submitting is true and correct information, that the company is in compliance with the state and federal equal pay acts, the company is in compliance with Title VII, the company complies with the Human Rights Act, but it also requires, beyond that, you have to provide information in terms of a representation that the average compensation for female and non-minority employees is not consistently below that for male and non-minority employees. So in other words, you've got to be saying female and minority employees are not on average consistently paid less than male and non-minority employees. And so they may get into that and say, well, we'd like more data on that, because you're going to have the information there. They'll be able to look and see what people are paid. It's anonymized in the sense that you're not reporting names, but if you're reporting titles, in many companies, you've got only one HR director. And if you're going to figure out who that is, it's not that difficult. So you're going to have to certify to not only that, but they also require a certification that jobs are not restricted to only one sex, but also a statement of how often the company assesses benefits and compensation, that when the company is informed of disparities in wages and benefits, that it investigates it and corrects them. But then also there's got to be an explanation of how the company goes about determining its levels of benefits and compensation. So it's more than just filing EO1 with a somewhat expanded employee list. You've got to give an explanation of how you go about deciding benefits and compensation for the company as a whole, and certifying to compliance with various statutes. I think that when people get to doing this, they're going to adopt fairly standard innocuous language that essentially provides nothing of use to the state. You would put in the form something like, well, we review market data available for companies in our field, companies of our size, geographic data, and we try and make sure that we're paying equal to market. Beyond that, of course, individual compensation will be based on other factors. It'll be things like years of service with the company, individual performance, educational requirements, the job itself, And so I think people will just end up filing yet another piece of paper that doesn't really say anything or provide any useful data. But that is a new requirement if you're with a larger employer. There is a somewhat related amendment that they did at the same time. They did as part of the same act to the Business Corporation Act. And essentially what they're saying that all corporations that are either established in Illinois or are incorporated somewhere else and are registered to do business in Illinois have to file an annual report. So now if you have 100 more employees, When you file your annual report, you're going to need to include some of the data from your EO1 report as part of your Illinois annual report. What's unusual is the Secretary of State, and this will go into effect for all reports filed on or after January 1, but the Secretary of State is then going to take that data and make it publicly available to people. So you're going to have the lists of identifying by race and gender and job category, and that's going to be available for each corporation. Again, it's going to be anonymized. It's not going to be listing particular people, but that's information that is now generally not available to people without maybe doing a FOIA request. So this will be presumably thrown up on their website. Their website is fairly easy to access. I probably look at it for different purposes 2-3 times a week. But that'll be a change. One thing that struck me as odd about this is they did it as an amendment to the Business Corporation Act. LLCs are not corporations. They're limited liability companies. They have their own separate statute. So this requirement apparently applies only to businesses that are in the form of a corporation. If you're an LLC or a partnership or an LLP, they didn't amend those statutes. And even lawyers sometimes forget that LLCs are not corporations and that it has its own governing law. I think it's probably an oversight, or maybe their assumption is nobody that's that big is an LLC. Well, that's certainly not true for law firms. There are plenty of them out there that have more than 100 employees and are still in a partnership or a limited liability company form. They don't have to comply with this requirement because that's not the act that was amended. Okay, VESA. I think that's the screen. Gotta scroll down. My thing got a little blocked here. VESA, of course, is the Victims Employment and, excuse me just a sec, and Safety Act. VESA's been around for a bit of a while. It's, I forget exactly when it was adopted, maybe a dozen years ago, something like that. And what they've done in terms of an amendment is to expand what is considered a qualifying event. It previously had been that the statute, the purpose of the law is to give people some time off if they have become the victim of certain types of crimes. It had been limited to domestic violence, gender violence, sexual violence, and what they've expanded it to is to say all crimes of violence. And so that it's not looking at just certain specific ones, it's any crime of violence, but they also include things like intimidation, harassment, and other crimes that we wouldn't necessarily think of as being violent, but may be in that neighborhood. So if you've got somebody who's being stalked, even if there's no actual violence, that's going to be covered by this. That could be considered a qualifying event. The other change that they made here is to expand it. And so now the definition of a family member or household member includes, again, you're expanding it to the grandparents, the grandchildren, your siblings, covering civil unions, but also they're saying any person who has a close association with the employee and is equivalent to a family. So if you say, they're just like family to me, well, it's the employee who gets to determine or decide who they consider to be just like family. That's not for the employer to say. And so that's an area that may have some issues. You know, because somebody may say, I want time off because my good buddy from the bar got attacked and he needs care and I'll be there for him right there at the bar. Well, you can still look and say, I'd like some documentation for that. And not necessarily of the relationship, but of the qualifying event. And you can talk to the employee and say, and what is it you'll be doing to help this person? Because the purpose is to take time off to get treatment, to get assistance from professionals, to go to court, to work with the police. But again, it can just be personal treatment and healing as well. But it doesn't mean you have to accept every request and just nod your head blindly. one of the difficulties now is that, you know, an employer can request documentation, but the documentation can simply be a sworn statement from the employee. If that's all they have, that's all you get to ask for. You can't ask for documents that they don't have and say, well, I need this document, you know, and if they don't have it, they're out of luck. The employee gets to pick what documentation they'll provide. You can also only request the documentation once within 12 months. There's a new confidentiality requirement that had not been in there before. I think it would have been kind of obvious, but the other thing that is now clear and is also obvious is that if you come to work and say, you know, my husband got beat up and I need to take some time off. Oh, who beat him up? Well, I did. You know, you can't be the person who inflicted the violence and then ask for time off. That is not covered. It seems obvious, but now it's clear in the statute. So if you had plans on taking time off based on beating your family members, well, think again.
John, we got a couple minutes left. Perfect timing with questions and
Indeed.
answers. Yes.
All right.
Anybody in the group want to come off mute and ask any questions, or feel free to type in the chat.
Show us your faces, please.
Or in fact, is a certain number of employees or all employers?
I'm sorry, I couldn't hear the question.
I'll type it.
I think the question was relating to the number of employees required under VESA. Yeah, it's 50 or more.
Okay.
Yeah, and that's 50 or more in the company, not necessarily in the same 75-mile radius. So it's not quite like FMLA. I think that was the question, right?
I have a quick question. Does it behoove us to have some of these policies in our handbooks, even if we currently do not have 50 or more employees, so that upon, you know, we, at least our company, we have about 20 employees right now, but that's not to say in 5 years we don't have 50. Is it still good to have them until they become applicable?
It would depend on the policy and the company approach, in the sense that there are certain things that companies will look at and say, we want this to apply to everybody. And a classic example of that would be FMLA. You know, you're only eligible for the FMLA if you work at a work site where there are 50 or more employees within a 75-mile radius.
Yeah.
Well, you know, in some companies, that's like, okay, that's headquarters and our other big office, and the rest of you don't get it. Companies may decide we want to expand that benefit or the protection, you know, not necessarily protection of the statute, but we want to expand that as a company provided benefit. Then if you want to do that, you certainly can, but you need to make it clear that what you're doing is a company policy, not the statute. And you want to make it clear you're not covered by the statute, because most cases, if you've got an employee rights statute or an employee benefit statute, when there's a violation, the big kicker again is they get to sue you and ask for attorney's fees. If it's a company policy, then it's just a breach of contract claim and they're not entitled to attorney's fees. And so that you can do it if the company wants to, but it has to be documented clearly that we're not adopting this statute. It's something like it. As to whether it's a good idea to do in advance, that really depends on your business, and you know, you're certainly free to adopt any of these different benefits and protections for people. You can have VESA if you've only got 25 people.
Okay, good. Thank you.
Sure.
John, we really appreciate your time today. Thanks for spending an hour with us.
Of course, my pleasure.
We'll get out the email with your slides on it, and I will get everybody the recording as well later this week. So thank you for everybody's time, and have a good one. Have a great holiday if we don't see you.
Thank
Take
you.
care, everybody.
Hi, everybody.
Bye.